This is Lily Ledbetter. For nearly 20 years, she worked for Goodyear Tire and Rubber Company until she discovered she was a victim of pay discrimination.
She didn't discover until the very end of her career that she was being paid 40% less than her male colleagues. Someone dropped a little note on her desk. That's how she discovered it.
The U.S. Supreme Court in May of 2007 reversed a ruling in her favor that would have compensated her for the gap in pay compared to her male counterpart for those 2 decades. The court, in a controversial 5-4 decision, ruled Ledbetter and other women complaining of pay discrimination need to file a formal complaint within 180 days of that discrimination actually occurring. That's not realistic, argue civil rights activists.
Oftentimes, these women will never, ever even know that this discrimination is happening for years and years and years afterwards, as what happened in the Ledbetter case.
Assembly Bill 437 makes clear that if there's an act of discrimination in the workplace and that act continues, you have the right to bring your claim today and treat it as though there's been ongoing discrimination and get recovery for the period of discrimination during the entire period of time.
Assemblyman Jones's bill has broad support from labor and civil rights groups. Jones insists opponents of the bill are just trying to mislead Californians.
We're not asking companies to do anything differently than what they've been doing for the past 3 or 4 decades, and that is don't discriminate against people.
This report was produced by the Speaker's Office of Member Services.